Hi everyone, my name is Ramana Reddy and I am a lawyer from Hyderabad. Today I wanted to talk to you about what is the first thing that you look at whenever there is a contractual dispute. So let's take an example. Let's say that you supply some goods, or let's say that you supply chairs to one of your customers, and there is a written contract that says that your customer should pay you 40 lakhs within X amount of months, and your customer fails to pay you, and the agreement is reduced to writing, and there's a contract. And this is just one example. This can be multiplied over hundreds or the thousands, because there can be all sorts of disputes under a contract. There can be a dispute about that somebody has unfairly terminated the contract, or anything like that. So then, whenever you have a contractual dispute, what do you look at? What is the first thing that you look at before you do anything else? Now, I think the first thing that you should be looking at whenever you have a contractual dispute is the dispute resolution clause, which basically means, if there's a dispute between the parties, what does the contract contemplate? How does the contract, how does the contract lay out what the parties should do? Now, so the first thing to see, I think, under the dispute resolution clause is whether there is an arbitration clause or not. So if there is an arbitration clause, then you don't have to, then you will not, you don't have to file your case in court and litigate the entire thing in court. You can ask for an appointment of arbitrator under Section 11 of the Arbitration Act, and you can go to arbitration. You'll have to look at what is the venue of arbitration. If there is an arbitration clause, all this is applicable. So you'll have to look at what is the venue, which is, where will the arbitration be held? What is the seat? Which court will have jurisdiction over just all the procedural aspects of the arbitration that that is to be entered into between the parties. Now, even assuming that there is an arbitration clause, let us say that there is an admission of debt by one of the parties. So let's say that in the example where I supply chairs, the customer, or the one of the directors of the customer company, he admits in an email that, okay, look, I know I owe you this amount of money, and I am sorry that I am not able to pay you within time, but I will do my best to pay you within X amount of time. Then in that case, you can file a case against that company, and you can move, you can drag him to the NCLT, which is, the National Company Law Tribunal, and pray that the company be wound up, because admittedly there is a debt, and that company is not paying that money that is due to you. The only caveat here is that the disputed amount, or the amount that is due to you, should be more than 1 crore. If it is more than 1 crore, you can go to the NCLT. Or otherwise, if there is no dispute resolution clause at all, then in that case, your remedy will probably be with the civil court, and you will have to build up a case for recovery of money to see how you can get your money back. Now, in whichever route you go, whether it is the arbitration route, the NCLT route, or the civil court route, depending on how your contract is structured, always begin by issuing a legal notice first. Don't just go to any of these forums directly, because there is a chance that if you issue a legal notice, your customer company may just end up paying you, and you don't have to litigate the whole thing. And also, it's a good practice to issue a legal notice. That's something that the court will look upon favorably if you ever go to court. So just to sum everything up, the first thing that you look at whenever there's a contractual dispute, it could be any kind of a contract. The first thing that you look at whenever there's a dispute is the dispute resolution clause, which could be if there's arbitration, you go to arbitration. If there's an admission of debt which is more than 1 crore, you go to the NCLT, and if there is no such clause, then you just go to the civil court and you fight out your case. I hope that was helpful. Thank you for watching.